Delivery of judgment, division bench sitting singly, WBC 114019.
The Citizens Party allowed with remanding the matter back to the tribunal for a first opinion. The petitioner is directed to appear within 2012 will be too short. 20 January 2026. You communicate 20 January 2026, the petition will have to appear, otherwise it proceeds ex parte.
May I please your lordship?
Yes.
Lord, I'd like to mention item 12. Lord, I may not be able to appear when the matter will be called for. That's why, my lord.
Just wait, it's a 2018 matter, we'll examine past orders.
My lord, my submission kindly is that, my lord, long back in 2018, the file was taken by the party and two other inquiries already appeared file of
You see, these old matters are being listed at the instance of the registry.
registry, my lord.
We'll,
Only my deletion of my name only. That's I'm not no more in the case, my lord.
but that also we'll have to look at the records in past. Old matters, you ask somebody to be here, we'll
Lord,
take note of
My
it.
lord, the engaged, newly engaged will appear. I have talked to them. They will
It's
appear.
okay.
Obliged, my lord.
Lord, my lord, is motion case taken up on tomorrow, my lord, your lord. Motion case active on tomorrow, my lord.
Give it to the court master, let him take the record.
Obliged.
I have similar prayer, your lordship.
Give it to the court master.
Wait, please, your lordship. Lordship, I would like to mention item number 40, lordship.
1-4.
1-4. Lordship, yesterday I have submitted the adjournment slip, lordship.
Okay. Both sides are represented on the prayer made by learned counsel to the petitioner. List after ensuing, list 19 matter, give it fixed date after vacation.
Please, lordship. May it please, your lordship. Your lordship, this is regarding item number 28 of the supplementary list, your lordship.
Item number
28 of the supplementary list. Your lordship, we have filed for an IA last Friday. Your lordship may take up the matter along with the IA in the orders column, your lordship.
I will not come like that. You'll have, has to be listed.
Yes, lordship.
Okay. Item 28, both sides are represented. The learned counsel for the petitioner has submitted that an interlocutory application has been filed on 15/12/2025. Accordingly, list this matter along with the said interlocutory application.
May I please your lordship? With the consent of other side, I pray for adjournment of item number 20.
Item
20. Daily post list. Yesterday, I filed an adjournment slip.
okay. You are for the appellant.
Appellant.
Consent of the other side, the learned counsel for the appellant place for adjournment. Circulating an advance adjournment memo. Trade is allowed. The notice is adjourned today. List after ensuing winter vacation.
Lordship, after being vacation.
I pray for a date, lordship, only. Otherwise, lordship, because the interim order is operating, lordship.
Give it date.
Lordship.
January 20.
Interim order.
My lordship.
Continue. Interim order.
Interim order shall continue till the next date of listing.
Obliged.
My lordship, I want to pray for item number 24 and 25. My senior is in personal inconvenience. So kindly may fix this matter after vacation.
These are review applications. Please renew the prayer when the matter is called. Wait for some time, and when the matter is called, then renew your prayer.
Your Lordship. Your Lordship, I was seeking for requisition, Your Lordship, not for adjournment, Lordship.
Pardon me?
Your Lordship, I was seeking for requisition, Your Lordship.
Requisition, I will not come by requisition. It has to be listed.
Please, Your Lordship. Lordship, I beg to mention a fresh matter, active matter for listing.
Give it to the courtmaster.
Daily list item 1 for motion.
May I please, Your Lordship? This is the case of 2019 matters, and in this case matters, the record was called for. Then petitions was declared to be a foreigner's period to 25th March 2015. Let's hear in this case the petitioners and his fathers previously declared to be a foreigners in the schemes of 1966 and 71. Petitioners challenged the matters before the tribunal. Tribunal declares the petitioners and his fathers as citizens of India. This is the second times petitioners was
Where
declared.
is the earlier
foreign-
opinion?
Malay?
Which page is the earlier opinion?
Page 61, type is. Opposite party appears through his sons produce some document, peruse the reference, etc. and document produced. Opposite has produced a photocopy of the JCC and 1956 and PRC by the SD Rongia. The original JCC is said to have been lost. The document produced appears to be genuine. It is found that residing Tulshibari Rongia since 1966, and as such, he is held not to be foreigners. Opposite party, case number so and so, so and so.
And where is the present opinion?
Malay?
27.
Page
27.
27.
Sixty-four is the notice against the petitioners. Against this notice, petitioners challenge, and he was declared to be a citizen of India. 64.
Ms. Verma, in page 61, what is this JCC? What does JCC mean?
Yes. JCC, 65 JCC. The original JCC is said to have been lost. The document produced appeared to be genuine. It is found that there is no. Page 64 manner, the have the petitioners declared to be foreigners 66 and 71, and notice was served to the petitioner. Petitioners appear before the tribunals, and tribunal declares him to be citizens of India. Again, this is the second proceeding, Malad. It starts in the name of the petitioners. Malad. judgments, it was said that the petitioners could not petitioners could not prove the residential status. So he was declared state foreigners of 25th March 1971. And in this case, by the villagers and these brothers and fathers all are given the evidence that they are residing in Kulchivari village since before 1966. Even the Gavura and circle officers also given the certificate that is residing since before 1970 in this Kulchivari village. And other hand, smellers, the petitioner also submit the cell bit 71, 70. Petitioner father's name is the migration certificates in 1956 is also attached here.
Yes. Okay. He's already been declared as an Indian.
This issue was shaken up in the second note opinion also, Lordship, that he has been declared as an Indian,
No, but this opinion status not challenged.
not Chinese.
26/6/89
Yes,
is
Lord.
declared to be an Indian. This is the order, there's nobody disputes it. Look at this transport record. It is down below the order copy.
I have this argument.
Residual capitalize, we allow this. But HS Sarkar learning for the petitioner also heard also for the respondent. By filing this writ under Article 226 of the Constitution of India, petitioner has received the opinion dated 10/1/2019, page 37, passed by so and so and so and so. Hereby declaring the petitioner for the petitioner, namely Santosh Biswas, son of late Jogesh Biswas, as foreigner of 25 19th Central Street. Next part. The petitioner on service of notice appeared in filed a written statement. His written statement. Amongst other, stating that the petitioner had, that the father of the petitioner had migrated to India from erstwhile East Pakistan prior to 1950 and obtained citizenship certificate in the year 1956 at Kandia. Ms. Verma,
Yes,
when this that SOP that is being drafted,
Yes, Lordship.
kindly also take note that invariably in every case, the documents which are filed with the written statement are segregated. Now, we are finding it difficult from the tribunal's records because this that certificate is annexed to the writ petition, the written statement. You will find the statement at paragraph 2, page 54. Citizenship certificate.
Yes, Lordship.
Now,
Annexure 2, Lordship.
annexure 2. But in this written statement that has been segregated accordance by
In the writ petition, it's not annexed, Lordship.
you see the it to the vote.
Okay, SOP follow.
No, but the tribunal has no business to segregate documents. It would have been easier for us to find it out.
The citizenship certificate, Lordship, yeah, it's not here also.
We won't comment. Every day we are fed up with making comments. Everybody here is a big shot. Nobody wants to look at the trial court records. It's very insignificant. Question of prestige. Why will the High Court lawyer look at the trial court records? I flagged it.
This one. 1956 document, Lordship.
But somebody must know how to read evidence. Everybody who wears uniform may not know how to read trial.
It should come with the WS, Lordship, like,
It was annexed, but the tribunal has segregated it.
yes, Lordship.
Mr. Sarkar is a busy man. He did not have time to see whether this written statement has annexes. He'll find it out, annex it.
I tried to find it in the writ petition, Lordship, it was not there.
Not there.
Actually, Lordship, there is no uniformity in the procedure, what we have been observing all these years, Lordship. Yes, Lordship. And Lordship, I think at that point of time, no AGP was also there, Lordship. I just checked page. This is at page 61, Lordship. Where if Lordship looks at the order, it is only the member who is present. There's no government council present. Yes, Lordship. No documents were appreciated, Lordship. And in the second opinion, documents are there, they have been appreciated, looked into, and then the opinion has been passed. The first opinion, Lordship, where the petitioner has been declared an Indian Lordship, there's not a single document except for some PRC, which is not there in, which is there with Lordship just showed me, Lordship. Citizenship Act. And another thing, Lordship, 4 matters have been clubbed together. So now we do not know if reference was against one or against 4 of them. No, yeah, but the records don't show that there were 4. Or the Lordship has not called for these records. But that PRC certificate is the 1956 certificate is the Lordship. This was passed in 2019, I think. Yes, in 2019 was the Lordship.
Elder brother.
Of Akhil Chandra Biswas, within bracket exhibit 7. And electoral photo identity card, proved in original, of Jogesh Biswas, sorry, Nikhil Biswas, within bracket exhibit 8. Next part. The learned tribunal discarded all the exhibited documents as those documents do not establish that the petitioner was a Indian citizen. Stop. In exhibit 1, the date of execution of the agreement was not found. Moreover, same was a arrangement agreement. The sale deed was of 1/9/1971, which was post cutoff date of 25/3/1971. As regards Exhibit 3, the same was discarded as the principle of res judicata embodied in Section 11 of the CPC would not be attracted for proceedings under the Foreigners Act. The other documents were also discarded as they do not prove the existence of the petitioner prior to 25/3/1971. Next. The challenge to the impugn opinion is opposed by the learned standing counsel for the FT and border matters on the ground that the opinion dated 26/6/1989 within bracket Exhibit 3 that was relied upon by the petitioner does not assign any reason to declare petitioner and other family members to be not a foreigner. And no evidence was left in the said case to prove that the refugees were not a foreigner. Next para. Insofar as the application of principles of res judicata in proceedings before the Foreigners Tribunal, we may refer to the decision of this court in Ms. Verma, I forgot. You have
Abdul
one?
Quddus.
Pass it on. Pass it on.
Yeah.
Pass it on.
Did you?
Of the Supreme Court of India, in the Supreme Court of India, in the case of Abdul Quddus versus Union of India and others, Union back 2019, 6 SCC 604. Full stop. The said decision was rendered on May 17, 2019. Stop. Accordingly, the opinion of the learned tribunals that the principles of res judicata does not apply in the proceedings of Foreigners Tribunal is deemed to have been prospectively overruled. No, retrospective effect. Retrospective. Full stop. The set principles has also been followed by this court in the case of Jahir, Jahir Ali versus Union of India, within bracket 2021, bracket close 3 GLR 105, equivalent to 2021, within bracket 2, bracket close GLD 596. Next paragraph. As the tribunal, as the learned tribunal did not doubt that the proceeding in the proceedings of MFT case number 1729/88 was not the father of the petitioner, or that the proceeding in MFT case number 1728/88 is not the petitioner, comma. As exhibit 3 is concerned, comma, principles of res judicata would apply in respect of the petitioner. Accordingly, the Indian opinion is not found to be sustainable. Full stop. Accordingly, comma, the opinion dated so and so, page 37, is hereby set aside. Next paragraph. The matter is remanded back to the concerned, to the said learned tribunal to consider the case of the petitioner afresh by giving him an opportunity to prove that the petitioner, namely Santosh Biswas, son of late Jogesh Biswas, a resident of so and so, page 37. So and so is the one and same person in whose favor the previous opinion dated 26/6/1989 was passed by the learned foreigners tribunal of Guwahati in MFT case number 1728/1988. And that he is the son of the Jogesh Biswas. The proceeding in MFT case number 1729/88. Full stop. Next paragraph. If it is found that the present petitioner is the same person, was the proceeding in the earlier proceedings, the present reference against the petitioner, referred to in the impugn opinion dated 10/1/2019, passed by page 37 shall be dropped. Next, the petitioner is on bail. Right. Order dated 24/4/2019. The said bail is extended till January 30, 2026, within which time the petitioner shall appear before the Foreigners Tribunal, number 5, Kamrup Rural at Rangia, Kamrup at Rangia. And by producing a certified copy of the order, present before the said learned tribunal all the documents to establish that he is the proceedee in the previous proceedings, and that he is the son of the proceedee in MFT case number 1729 of 1988. Next part. Extension of bail shall be subject to further orders that may be passed by the learned tribunal. In the event the petitioner is found to be an Indian, the conditions imposed for bail shall cease to operate. The bail bond would stand discharged. You had, your bail is till 30 January 2026. You'll have to appear before the said date, before the tribunal. So the records be sent back expeditiously, along with the copy of the order to be made a part of the record by the said learned tribunal. The extent is written.
Item 2 for motion.
May I please answer? My lord, from in the first phase, I see that there is the report of election commission, election officer in page 9, but I do not see the report of election officer. I only see the LCR. Moreover, the reference is also not seen in the LCR.
This is a reference at page 13. This is the reference. First page we turned out is the reference.
The LCR.
Yes. Look at this. Look at this.
An election officer's letter. Page 9, it is written as page 9. Page 1,
That
left
may
side.
be one of two pages here and there.
Oh, I see that.
No, no, don't go by that writing. Look at the document. Page 11 is the document, page 11 or 13, I forgot. Yes, that is the reference.
That is the reference, but the officer who sent the report to SP provided the reference, but that
Everything
officer.
is there. Look at one page below. You find everything.
Yeah. All these pages are not filled up. So that I draw your lordship
Oh,
attention.
we will take care of that. Don't worry.
That's fine.
This is a ERO reference. Your submissions are misconceived because this is not a reference under the Foreigners Act. This is a ERO reference which comes to the Representation of the People's Act. And the Supreme Court Police has got no option but to send it to the tribunal, whether it is right or wrong. And the Supreme Court in the case of Saravanan Sonowal says send it. So
But,
therefore, that argument of yours will not take us anywhere.
SP has to apply his mind.
No. Yes, sir. But in this reference, he's just a post office.
Referral authority, it is,
You see, not one. I have authored not less than 10 judgments where we have distinguished it. Not one. In a bench with quorum having me, I have decided 10 cases.
now we have also judgment of Supreme Court, the referral authority must apply his mind. Supreme Court
Did you
judgment.
read that judgment before citing? You have not even cited. But please tell me, have you read that judgment?
I will give. First, I am arguing on merit. I am Honua Begum, is a Hanufa Khatun. Honua Begum. Page 12 is the NRC 51. Is this NRC, my father's name is there, that is Shukur Ali. And 66 voter list, page 14, is the voter list of my parents, Shukur Ali and Majida Khatun. And this is exhibited document, that is exhibit A. Nineteen 70 voter list, page 16. Here, my uncle Nizamuddin and his son Hazrat Ali's name is here. At that time, my father was not alive. Because here, his name is not here. But my uncle's name, Nizamuddin, was here. And Nizamuddin's son is Hazrat Ali, serial number 146. So he is my cousin brother and he has adduced evidence in my favor.
Unfortunately, your written statement doesn't say so. In your written
In
statement.
evidence, it is there. In evidence, in my evidence, kindly see my evidence.
No, evidence you can introduce anything, but the pleadings are not there.
In WS, that is not mentioned, but in evidence, it is mentioned. So I think your lordships may kindly take notice of this. Evidence of petitioner, kindly see page 42.
Yes.
42, written statement, it starts as 42, WS, yes, 50, page 50. Here, page 53, kindly say that my name along with my younger sister, Romisa Begum, have been mutated Borpeta Circle dated so-and-so over the name of my father land as legal heir after my father expired, along with other two uncle Nizamuddin and Hassan Ali. Covered by periodic pata number so-and-so, dag number so-and-so of village, Radhakusi, Mauza, Nagaon,
Where is the voter list of 1970 and 1997?
1970.
1997, which page?
1997, page 28. 70, page 16. And not only less, thereafter, after few years, her name is there.
Yes, you were referring to the evidence, your uncle's name you said is there.
Uncle has not given any witness. His
No,
son.
no, no. In the written statement, the description of the family was not there. You said it is there in the evidence of DW1. Where does
Yes.
where does the petitioner in DW1 refer to the name of the father, grandfather, and uncle?
In affidavit, she has stated.
Where, which paragraph?
Page 52.
Okay. 8. Para 8, I couldn't read it.
Yes.
Please read that paragraph.
That my name along with my husband name has been covered in voter list number so and so, serial number so and so, but in the voter list
You
of
see, we
my,
are asking you a simple question. Where is the statement in the written statement containing the name of your father and your
in
uncle?
written statement that
It's not there.
evidence,
Now in the evidence where it is there.
evidence part is there. Let me see evidence
First.
part.
You said that it is there. We are asking you where.
I'm telling you. Only see page 50 onwards.
No, just tell me the exact paragraph. It's simple as that.
Para 11, page 53.
Para 11.
That my name along with my younger sister, Romisa Begum, have been mutated Borbata Circle, dated so and so, as a minor over the name of my fatherland as a legal heir after my father expired, along with other two uncles, Nizamuddin and Hassan Ali, alias Uddin, covered by so and so. But where my and my younger sister title name have been dropped and written only as Hanua and Romisa in place of correct name Hanua Begum and Romisa Begum. Now this Nizamuddin's son Hazrat Ali is the DW number 2. Because at the time of evidence, this Nizamuddin was not there. His son came and said that she is my cousin brother. Well, she took birth at village Radhakusi. Everywhere Radhakusi. Then Balabara to her husband's house. In between there was in one place, but due to erosion of river, she shifted.
Xerox copy.
Xerox copy, but Xerox copy exhibit cannot be done. No, signature is there, my lord. Member signature is here. In, let me see. Here, voter list of 1966. Is the member signature? You see, please. Eight. Signature is there. One. Page number 33. Page number 33.
Oh, no. The voters list.
Voter list, that, I am also saying voter list. Voter list of 66, it is the signature of member. Jamamoli. Hello, see Jamamoli. Jamamoli.
Exhibit E has been cut down.
Please come.
Zamamoli has not been signed, Lordship.
That's right.
No, issue authority.
It is signed, it is Jamamoli, it is signed by member, yes.
Next one. Original single.
Online copy.
Original single.
It is it is signed, what is it?
We approved in original, case number 180%.
Yeah.
It is approved in original.
That is
That's not-
the mistake of the
No, sir.
tribunal.
Certain
What can I-
document that has been proved in original, Lordship. There is a seal that proved in original and that has been signed. Some of the documents, I think they have not produced the original, so it has not been proved in original. The seal is also not there, signature is also not there.
No, signature is there.
No, he proved in original.
Signature is there, seal is there.
Okay, এইটো
But-
বাকি সেই সামাজিক কথা কৈছে নে এই সাইন এইটো আছে
Uh,
কেস নাম্বার
Online, no, my lord, our submission is this, when the learned tribunal has put his signature, it is proved in original or not, that is the duty of the tribunal's member. This is the Jamamoli, it is signed by member. This is Jamamoli. This is Jamamoli. It is signed by tribunal member. And this Gaura's certificate, it is also signed. Then, my lord, it is the certificate, it is also signed, written as proved in original.
MLC,
M.
empty plus. No, you can see.
M.
Is there Epic, sorry. Epic is the one signed, but the member is not signed. Seal is.
Member has not signed.
He also there, seal is there, sign is.
Sign is not. Sign is not yet. But my lord, it is the work of the tribunal and the tribunal's mistake whether we should suffer. And so far, what I understood by limited understanding that if a document is not to be accepted, then it is returned. Then the seal would be there, the member's signature, member's seal is there, office signature is there, but no signature is put. So it means what? They have accepted. So how the party will understand that the member has not put his signature? It should be, but it is not. But let me now invite your worship, kindly see the impugned order page 66.
There's another small thing which I've noticed. The petitioner was born in 1959. And the land was mutated to her in 67 when she was just 8 years old.
That may be. Necessity is the mother of invention. Actually, my lord, earlier it was not done, but because of this type of cases, now
The Lordship will fix up another date for this. Yes, Lordship. Hmm? TNN, no? What moment? We can take it. Lordship, Mr. Pine's name may be reflected. He'll have the records.
Yes, yes, it may be given in my.
Item 3 for
Total.
motion.
Fine. I think 60 of them are
May please, your lordship. My lord, part of the merit of the case. My lord, I have gone through the records, my lord. Trial court records and found that the reference, my lord, LBO report, my lord. There is no shards.
Pardon me? Mr. Siddhar, how did the petitioner link herself to her projected father?
My lord, father's name is in 1966-70 voter list.
No, how
also.
did she link herself to her projected father?
My lord, he has claimed based on the 66-70 voter list, but documents, my lord, connecting documents is the Gabura certificate and evidence of his cousin, of her cousin. And some documents, my
Gambura
lord,
did not come.
my lord,
The Gambura did not come to depose.
did not come, my lord, that is there. My lord, the petitioner is in divorcee. And after return to her parent house, her name also listed with her, showing her father's name
Where
and
is
along
that?
with the brothers.
Where is that?
My lord, lordship will kindly have to look at page 55, the voter list,
55.
55. 55, I have a translated copy. Then, my lord, here, number 1. Serial number.
That is voter list of?
Yes, my lord, 2014. 2014, my lord, serial number 334, Ambazali, my father's name. And my name is at 344, Joygun Beva,
This document and your business statement at page 18.
my lord.
This document is not referred there in page 18.
Yes, my lord.
It is not also
Yes,
exhibited
it
in
is
your.
not
evidence.
mentioned, that is there, my lord.
In evidence also, it was not exhibited.
Not exhibited. The prima facie, my lord, she is not the foreigner. And the reference report also, my lord, goes to show that no case is made out against her. But there are lapses in the trial on the part of the petitioner. These documents are not produced. But how the tribunal has considered, my lord, the inquiry reports, then, my lord, the documents which were produced, not considered, my lord. And her cousin was examined. My lord, kindly have a look at, my lord, the inquiry report, the LBO report.
You've seen that
report.
this is again that, what you call, a reference made by the electoral registration officer.
My lord. My lord, LBO, based on the LBO report. LBO report, my lord, column 15, the column indicates whether migrated into Assam. The inquiry report endorsement is no. Then, my lord, the column 16, place from where migrated not mentioned, and the charges whether in before 1/166 no mention, whether it between 1/166 to 71 no mention, or after 1 or after 71 no mention. My lord. Where is the charge against me? My lord? As per the LBO report, the inquiry referral authority has not seen it and made reference. My lord. The column 15, there is a indication whether migrated into Assam, yes or no. No has been endorsed by the LBO. The reference is uterus. My lord, there shall be a balance between the two, my lord. My lord, maybe. My lord. My My lord, in WS, there is a statement that the case has been referred without conducting any investigation. Without, and, and the, my lord, the inquiry, LBO report indicates that no case is made out, there is no case against me, my lord. No allegation that I have entered into Assam. There is specific endorsement by the inquiry LBO, my lord. And where is the charge against me? No indication. Which category? No mention. So it is based on reference which is mechanical. It cannot be sustainable, my lord. My father's voter in 1966-17, father's land documents has been submitted, Jamamanti copy has been submitted, not considered on the ground that why revenue paying receipt is not submitted, why land sale deed is not submitted. This cannot be. Land sale deed is also there, but failure, there is a failure on the part of the proceeding that it was not produced before the trial court. So, my lord, lapse is there on our part, but there shall, why the lapse on the other part shall not be taken into consideration, my lord? My lord.
Father was arrived.
My lord, at this stage, I cannot say, my lord, but this voter list goes to show that in 2014, father was alive. At that time, father was 78 years. At this stage, may not serve. Not 10 years, 20, 11 years.
Yes, Ms. Verma. You are relying on any citations?
My lord. Yes, my lord. I have a citation, my lord. Yeah, yeah. My lord, it's a decision of 26/5/2025 in WPC number 330/2020.
WPC?
My lord, WPC 3330/2020. My lord. Paragraph 31, my lord, party নাম তো হল রফিকা বিবি alias রফিকা খাতুন। In this case, lordship has held under paragraph 31 that when there was no specific finding by the inquiry authority that the petitioner is a foreigner migrated from specific territory Bangladesh, it's not sustainable. Inquiry authority specifically stated in the report that petition was not available in the address.
Paragraph number?
My lord, paragraph 31. My lord, paragraph 31, I am relying on the subpara 1 and 1 C and D. মুজিবুর মিয়া টুলবাই দিয়েছেন। Also, my lord, 32. 32 is the conclusion of this oral court. There is lack of, my lord, existence of main grounds.
So, related is the government. One of the hasn't been on. Not only.
Take a short break and come back.
My lord. Illegal immigrant, which is denied by the concerned person, and thus there is doubt and dispute about the nationality of the person. However, in the present case, no doubt about the nationality of the petitioner has been raised on conclusion of the inquiry. So can inquiry officer, as per the inquiry officer, I am not a migrant. I am, there has been no indication that I have entered in between 66, 70 or after 70. There is nothing mentioned, my lord. My lord, under paragraph 29 of the judgment, the lordship has discussed about the full bench decision, paragraph 93, 94, 95, 96. And my lord, subsequently also 98, 99 also under paragraph 30. So considering all this honorable court has has rightly held that this reference cannot be sustainable. So according to my submission, my lord, this present case is squarely covered by the decision in the case of Rofika Bibi. And apart of this material, my lord, submission, my lord, if we go by merits of the case, my lord, my lord, the impugned order simply discarded the Jamamundi voter list of 1966-70. The Jamamundi has been discarded, saying that in para 7, on perusal of the record, it appeared that though OP stated Ambaz A, her father, but in exhibit Go, copy of Jamamundi, the name was not tally with the others submitted documents. This is absolutely wrong, my lord. And because the 66 voter list father's name is Ambaz Ali, son of Askar, and in the Jamamundi copy, which has been produced in the trial and also annexed in the petition, my lord, annexer 9, page 42. Here, father's name is Ambaz Ali, father Askar Ali. Where is the, my lord, mismatching of name, my lord? In the 66 voter list, father's name against his name is against father's name, grandfather's name is written shortly Askar, but in the Jamamundi copy it is Askar Ali. Can it be, my lord,
Which page is that? That Javamandi and
my lord, Jamamundi at, my lord, vernacular lordship will find at page 43, translated copy at page 42. Jamamundi
No, I don't know, this is which.
Page 25 and page 43. Lordship may kindly compare about the name of father's name and grandfather's name. Where is the mismatching? Only my lord 66 brutalist grandfather's name against his father's name is written in short Astor. And lordship, my lord, in this connection, my lord, we can rely the judgment of Supreme Court in Sirazul Haq. Minor name discrepancy and shifting cannot be a ground to doubt one's citizenship. I can also rely, my lord, Mujibur Mia case. T21. Learned Tribunal held that why revenue being received other land documents was not produced. But where is the, my lord, objection to my documents? Unless, my lord, any contrary materials, my lord, cannot be discarded, my lord. The Regulation 41(2) of the Assam Land Revenue Regulation says, my lord.
Yes.
My lord, in this, uh, the Learned Tribunal also recorded finding that the prosecutor unable to say the date of birth. That is also a point, my lord, has been raised. But when she was examined, she declared her age to be 37 years on the date of cross-examination. Is it not an amount, my lord, to at least to say the year of birth? The poor people, illiterate people from remote village. This type of fault, my lord, a minor omission of this category people cannot be fatal. when there are so many lapses on the part of the state in initiating the case, my lord.
No, cross-examination doesn't have that age of 37 years.
Yes, my lord. Yes, my lord. Yes, my lord.
Which page is it?
Page 33, I'm referring the photocopy of the original. Deposition of DW1, aged about 37 years.
I thought you said the cross-examination.
Hmm.
My lord,
This
yes. Yes, sorry, I'm wrong, my lord. In
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 the
oral,
form-
oral deposition.
Form of deposition.
Yes, my lord.
You know something very interesting. This is, this name and age is not an oath.
My lord.
No, not that. Just telling
That
you
much
that-
technicality should not be, my lord, applied.
Yes,
And-
Ms. Verma.
Lordship. First, I would like to come to the LGO report, Lordship. The records are with me. Lordship, if this is turning the records. At page 8, my friend has pointed out the empty columns or at page 9 and 10, Lordship. At page 8, serial 7, Lordship, there is a noting by the LGO Lordship that the voter could not furnish her documents at the time of verification. The burden to prove her citizenship is with her. If she will not submit any documents, Lordship, after that, there is nothing more to add to the LGO report, Lordships. And then, Lordship, at page 6, no? At page 6, Lordship, the SP report at serial 11, grounds for having reasonable doubt that person concerned is an illegal migrant. The suspect entered into India, Assam on or after 25/3/71, as she could not produce any documents to prove her citizenship, that she is not an illegal migrant. So these two no, observations are enough to send this matter to the tribunal for adjudication whether she is an illegal migrant or not, Lordship. And so far, my friend has referred to so many judgments. We have hundreds and thousands of judgments to place that she has not been able to show her linkage with her father in any single document on papers, Lordship. Nowhere there is a single document showing her name with her parents, her name with her father. Her first voters list, Lordship, it comes at page, at 28 years, Lordship. I just checked, Lordship, just. For the first time, her voters list comes, Lordship, in 2012.
Page.
Oh, Lordship, page 51, Lordship, 2012 voter list. This is the first time her name appears with her husband at the age of 25 years. And in 2016, when she deposed, she was 37 years. So I was just trying to calculate that when Lordship asked me. So at 25 years, whether she is that same person who deposed before the LBO Lordship in the year 97. 97, no age was given. She does not recall her age at all. And even in the police verification, her name is not here because she did not give her age details about information about her age, Lordship. That was in 97. In 97, no age, nothing. In 2012, first time her name appears at the age of 25 years. And 2016 in her deposition, she is 37 years. And not a single document to show her linkage with her father. And okay, citation too. my paragraph first. Yeah, we just. Finally, been thoughtful in hospital. Daniel, that's not judgment, dear. 245 of 2019. Decided on 28 to 25. Regarding the LVO report, Lordship, I would like to cite a judgment, which is getting it. Lordship, we take note of the records, page 6 and page 8, Lordship. Page 6, serial 11.
Page
Page 6, serial 11, Lordship.
of the.
The LCR,
yeah.
Lordship, yes, Lordship. And page 8, Lordship, serial 7, there's a noting here by the LVO. The voter could not furnish her documents at the time of verification. That was in the year 3rd of October 1997. I मुझे listen. I will the cousin. Cousin need to come now, not cousin need to come now. It will be there. About detail. And that's the I got really good at that. WSO को दिया थी WSO देखने नहीं अगर अंदर सुनने वाले जी कोई देखने की बोल लगे कितनी डिटेल Each says would they need you. I think the revenue is there as well. Give him the age to be good. Below. 888. Paragraph 8.
Uh, 245/2019. Judgment dated 28 to 25. Cabinet is 9 अपने काम न करे
Lordship, I have shared the judgment, Lordship, which is a very recent judgment. Lordship, paragraph 15. Lordship, I would be referring to paragraph 15, 18. Sorry? Yes, Shukurjan Nesa. Lordship, I'm referring to paragraphs 15, 18, 19, 20, and 21, Lordship. Exactly on the same ratio which Lordship, this matter is now being taken up. Then Lordship, I would even like to refer to a judgment on the written statement, Lordship. Sarbananda Sonowal, Lordship, paragraph 26. Sarbananda Sonowal, 1. One, Lordship. Paragraph 26 says that there is good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country. In order to establish one's citizenship, normally he may be required to give evidence of his date of birth, place of birth, name of his parents, and their place of birth and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under section 6A 1D of the Citizenship Act. All these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given evidence on these points, the state authorities can verify the facts and can then lead evidence in rebuttal if necessary. If the state authorities dispute the claim of citizenship by a person and assert that he is a foreigner, it will not only be difficult but almost impossible for them to first lead evidence on the aforesaid points. This is in accordance with the underlying policy of Section 106 of the Evidence Act, which says that when any fact is specially within the knowledge of any person, the burden of proof that fact is upon him. That burden of proving that fact is upon him. Lordship, paragraph 26 is absolutely clear, Lordship. No such information was furnished to the LVO, and the whole neither the information given nor any document submitted. Now, claiming that the report of the LBO is not tenable, Lordship. That does not hold feet anymore. And Lordship, written statement again, there's another one which I would like to refer. This is Rashmi Nara Begum, Lordship. This is even reported in 2017 for GLT 346. Lordship, 2017 for GLT 346. Paragraph 25, Lordship.
Rashmi Narayan, what did you say?
Rashmi Nara, RASHMINARA, Rashmi Nara Begum. Paragraph 25, Lordship. Written statement is the basic statement of defense of a proceeding before the Foreigners Tribunal. Keeping in mind the mandate of Section 9 of the Foreigners Act 1946, it is incumbent upon the proceedee to disclose at the first instance itself, that is in his written statement, all relevant facts, especially within his knowledge having a material bearing on his claim to citizenship of India. Material facts pleaded in the written statement are thereafter required to be proved by adducing cogent and reliable evidence. It is also tried that a party cannot traverse beyond the pleadings made in the written statement. Sir, number to deliver. Central Council. Twenty-one people, okay, I'm making a date.
Oh, 59. Citizen Dr. Logas.
Madam, 16 or 37.
It was nice. Whose representation letters from them.
या फिर ठीक है डिस्ट्रिक्ट में नहीं 1979. 1980.
Yes. Bangalore.
1997. AJ9.
Dismiss now. Let this document be put, demanded on that count. Below. Office is 9.
Latest open 2014 with the 90% 1880. Boy, 80. Jorgun Mishra. That is all of nine. Yeah, it was 26. Lordship, the age discrepancy again. Is Lordship very alarming, Lordships. In 1997, when the investigation LGO went Lordship, no age was given. 2012, when her name appears for the first time, she's 25 years. 2016, when she is deposed before the court, she is 37 years. In 2012, if she is 25 years, her date of birth is 1987. 2016, when she is deposed, she is 37 years. Her date of birth is 1979. And I found out one just now, which is annexed. Voters list of 2014. Here her age shows as 26. So much of discrepancy all through. In 2012, it's 25, and now it's in 2014, it's 26. Lordship, we would like to give one citation on this also, Lordship, discrepancies of age. Basiron, 2018, Lordship. Lordship, another one which I want to rely on is the age discrepancies in the voters list, Lordship. 2018 1 GLT 372. Basiron BB versus Union of India, paragraph 30, Lordship. It's a short paragraph. May I read it, Lordship? Reliance placed in the case of Abdul Matali, Supra can be of no assistance to the petitioner in as much as it has already been clarified by this court in previous decisions that the said decision did not lay down any law and was a decision confined to the facts and circumstances of that case. Regarding discrepancies in the voters list which the petitioner contended were not her creation, being entered into by officials of Election Commission and therefore should not be used adversely against the petitioner, such contention is without any substance. the voters list were adduced as evidence by the petitioner herself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only the portions of the voters list which are in her favor should be accepted and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. Lordship. And lastly, Lordship, the writ of certiorari, we would like to rely on the Central Council proposition. Number to Jana. Upper line, okay. That's all.
My lord, I have a short reply. My lord, my friend is saying that my submission has been made from our side that the report, LBO report is blank. We have not claimed that we have not made any submission or claim based on the blank because of the blank and LBO report. We are not saying that. Rather, what has been entered in the inquiry LBO report, we are claiming on that report. Lordship may kindly have a look at the LBO report, column 14. Column 14. The LBO has found voter list of 1966. I'm not claiming that the voter list of LBO report blank. So we are also not relying upon the Amina Khatun case, my lord, which is on the basis of the blank LBO report. Rather, we are relying on the LBO report, my lord, where 66 voter list has been mentioned. And perhaps because of this, my lord, the LBO report, column 15 has noted whether migrated into Assam, there is a specific indication that is no. Have not, the procedure has not entered into Assam as a migrant, my lord. So the reference is reference has been based beyond the LBO report, my lord. Therefore, I am relying on the Rofika case, my lord. In column 16 is also not indicated whether she has entered on or after 1971 or in between 66-71 or before 66. Nothing has been categorized because the voter list of 66 was produced. And also there is a note that not migrated into Assam. So absolutely, my lord, reference is mechanical beyond the LBO report, my lord. So on that sole ground, my lord, this proceeding as well as the declaration is illegal. And therefore, my lord, I am relying on the Rofika Bibi case. And so far the other contention, my submission is based on that, my lord, and the LBO report and the Rofika Bibi case. But since my friend is submitting on the merit, so I am to reply on the merit also, my lord. Merit is, my lord, the full Sarvananda Sonal 1 case. Sarvananda Sonal 1 case, my lord, para 26. My friend has not referred the last line of the para 26. Whereas para 26 has says that evidence is sufficient. Evidence should be laid. 65, 78. My lord, I want to read the whole paragraph. There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be citizen of a particular country. In order to establish one's citizenship, normally he may be required to give evidence of his date of birth, place of birth, name of his parents, their place of birth, citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under section 6A1D of the citizenship. All these facts would necessarily be within the personal knowledge of the person concerned, not of the authorities of the state. After he has given evidence on these points, the state authorities can verify the facts and can then lead evidence in rebuttal if necessary. Where is the verification, my lord?
But if necessary, you have to see that.
My lord, my lord, therefore I am relying on the full bench judgment. Full bench judgment, my lord, there has been a categorical that when I adduce evidence, I claim that so-and-so, my father is voter in 1966-70. That is sufficient if there is no rebuttal evidence. Paragraph 1173. My lord, I want to read not the entire paragraph, but relevant paragraph. The relevant electoral rolls of 1970 containing the name of Abdul Ghaffur, who accorded to the appellant is the father of the appellant number 2, has also been proved and marked as Exhibit O. The state did not challenge the aforesaid version of the appellant numbers 1 and 2 during the cross-examination. The said version of the appellant therefore remained unrebutted. How, my lord, they have challenged? That is an important question. No rebuttal evidence, no challenge to my claim that my father is 66 and 70 voter list is appearing. There has been no challenge. And in para 1, 2, my lord, 1, 2 to 1, the same view has been repeated again, my lord. Here I am to read, my lord, the 1, 2 to 1. The appellant, by proving the electoral rolls of Exhibit B, C, D, could prove the names of their father and mother appeared such rolls of 1966 and 70 in respect of Junior LSC. Thereafter, her name appeared in the electorals of 1989. The appellant also proved the certificate issued by the village headman certifying that the appellant is the daughter of Saib Ali. The appellant therefore proved that her father's name is Saib Ali, whose name appeared in the electoral rules of 1966 and 70, which are relevant for the purpose of answering the reference made under the provisions of 1946 Act and 1964 order. Though the state has cross-examined the witnesses, there was absolutely no cross-examination relating to the claim of the appellant that Saib Ali is her father, whose name appeared in the electoral rolls of 1966 and 70 in respect of Junior LSC. In the evidence adduced by the state, the deposition of SI police, apart from the examining the Exhibit 1 report, no rebuttal evidence was also could be laid by the state to demonstrate that Saib Ali is not the father of the appellant whose name appeared in the aforesaid electoral rolls. My lord, this principle is the guiding principle framed by the full bench. The other judgment which was subsequently passed by the division bench are not following this full bench decision. So, but the Basiron Nessa case, this has been not discussed, the full bench decision. So that judgment is not acceptable, my lord. And my lord, my last submission is based on, my lord, another division bench judgment, my lord, the Idris Ali case. Idris Ali case, my lord, this honorable court held that strict rule of evidence is not to be applied in the case of citizenship. My lord, it is reported as 2020 0 Supreme GAU Go 192. My lord, actually, WBC number will be better, my lord. WBC number 4116 of 2019. My lord, decided on 27/2/2020. Paragraph 11, my lord, referring a Supreme Court judgment, my lord, in the last of this paragraph 11 has been quoted. My lord. My lord, tribunals generally regulate their own procedure, applying the provisions of the Code of Civil Procedure only where it is required and without being restricted by the strict rule of evidence act. Reverting to the case in hand, the strict rule of evidence are not applicable in the tribunal. In para 12, nothing is required to be proved beyond all reasonable doubt. We found that the observation of the tribunal pertaining to exhibit 6 and 7 are perverse, and therefore the entire opinion of the tribunal suffers from perversity. Such opinion must not sustain. My lord, merely, my lord, I fail to show any linkage documents of my father. My lord, although I have produced some documents in this writ petition that I am a voter, subsequently I am a voter with my parents, with my father. My lord, voter list of 2014 voter list, annexure 15. My lord, 5. Page 5, my lord, relevant portion of vernacular at 5.7, annexure 15. I am voter with my father. My lord, some lapse is on our part, my lord. Therefore, we are the proceeding, my lord, the poor illiterate lady, my lord, woman of remote village is before your lordship, my lord. It's a case of citizenship, my lord. At least she may be given another opportunity. Or when there is a reference is, my lord, mechanical. Some interference is required, my lord, in the light of the Rovika Bibi case. It is not a case that no evidence is laid, but the manner of discarding the voter list of 1966 and the Jamamandi copy is also, my lord, illegal, my lord. Jamamandi has been discarded, saying that why not revenue or paying receipt? Is it required to prove? Where is the objection? My lord.
Two 2018. Paragraph तो कोई के साथ देखिए इसमें 16. Lordship, on the rebuttal part, I would like to just add one more judgment, Lordship. Lordship, if this has to come, otherwise it will be incomplete, Lordship. 2018, Lordship. Lordship, Mr. Sharma will give it to the court.
The only aspect remaining is the rebuttal evidence lordship. 2018 4 GLT 360, para 16 lordship. If document placed by the proceedings is not present reliable and admissible evidence lordship, then question of rebuttal does not arise.
Please repeat again.
Lordship, para 16, 2018 4 GLT 360,
2018.
4 GLT 360, para 16,
This is
State of Assam and under versus Ohavali.
State of Assam versus
Ohavali, OHAB.
paragraph.
Paragraph 16. On the other hand, from the impugn order, we find that after narrating the case as projected by the respondent, tribunal observed that state did not examine any witness and failed to adduce any rebuttal evidence. Therefore, tribunal answered the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law laid down by full bench of this court in State of Assam versus Muslim Mondal reported in so and so. Under Section 9 of the Foreigners Act 1946, burden is on the proceedee to prove that she is not a foreigner but a citizen of India, and this burden never shifts. This burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must have relevance to the fact in issue. By mere filing of documents without examining its admissibility and without the documents being proved or without examining its relevancy, it cannot be said that the proceedee had discharged its burden. Question of rebuttal evidence by the state will arise only if the proceedee adduces evidence which are admissible, proved, and which have relevance.
My lord, against that, my submission is that whether the voter list of 1966, certified copy of voter list of 1966 and 1970 are irrelevant and not admissible, whether Jawabandi copy is irrelevant, my lord, inadmissible. When these are admissible, my lord, this principle here, this principle is not applicable in my case. However, my submission is, my lord, primarily on the LBO report, my lord. LBO report goes to show that I am not a migrant and no charge.
Mr. Here, Siddhar and counsel for the petitioner and so for the respondents. Arguments are concluded. The order is in.
My lord, I want to leave, my lord, I have another admission matter item 13. My lord, may not be, my lord, the matter may not be taken up, my lord, but we may be possible till.
Let your colleague remain. Will
Yes,
have
my
to
lord.
pass
Yes.
orders because
Yes,
it is
ma'am.
18 matter.
Yes, my lord. Yes.
Item 4 for motion.
My lord, item 4, I have committed some mistake here. Instead of Rongsai Police Outpost, I have mentioned in everywhere Rongzoli Police Outpost. PS is Sam Lakhipur, but Rongsai is under fall under Lakhipur.
Okay. Since these are
And report card.
Lordship, as per my instruction, Lordship, there is no outpost in the name of Rongsai.
no, he made a mistake. He is giving the correct name. Please write it down and give it to us.
Wrong side.
Second thing is that, Lordship, the IC of Rongsai outpost never visited to the house of the petitioner
He made a
number
mistake.
3 and 4. Petitioner number 3 and 4 to the house of the petitioner number 3 and 4. The IC never visited.
No, let him give the correct. Just write and give
No,
it to us.
both
My
petitioner
lord, the
belong to
report
the
report
different-
petitioner.
both petitioner belongs to the different police station, Lordship.
We understand. That's what he's saying. He's made a mistake. Let us have the,
Yes, I
give it now. But tomorrow goes to after vacation. Now, next 2, 3 days, we won't be able to accommodate.
My lord, report call for report come, my lord. Also, yes, I have received the instruction.
Nah, you have to give me.
Here also one, Razia Khatun lost an affair before the concern outpost regarding stolen of 4 numbers of cattle from her outside. In that affair, lordship, there is no name accused in the affair, lordship. Thereafter, the IC have visited to the house of the complainant along with the house of the petitioner number 1 and 2, along with the house of the VDP, local Gampaha, and etc. Thereafter, GDNT has entered in SGD number 276 dated 15/9/2025.
The response to the
Untuk
the response.
tahu sama.
Apa company? Jadi kan cuma kalau kita
Tahu itu apa nama itu komplain atau apa namanya semua itu.
bisa berikan nanti. my lord.
Police went to your house to make inquiry, in the meantime, the informant gave a statement against you for till their character.
My lord.
There are two ways. Number one, the note this and close the matter.
Yeah, correct.
Secondly, that we have the authority, either matter from the.
No, my lord, I'm not on that. I come before this only to know whether any case has been registered against us. But no case has been registered against us, my lord. You lost of kindly say. Oh. That is why if we got a case registered, we will take a appropriate step, my lord. We may surrender or may push for bail.
Lordship, it has two things, Lordship. Yes, the Indian case is not registered against the petitioner, present petitioner. Second thing is that, Lordship, one affair lost by one Razia Khatun, but her case is already registered. Lordship.
Recently registered. After getting notice of this from this honorable court. That is why I come, my lord. For 2 months ago, FIR lost by that lady, my lord.
No, in that affair, Lordship, name is not shown. So sometime may be required for investigation, Lordship.
No, no, not the investigation.
Yes, Lordship.
You see, come to page, four of your comparison.
For space for.
Statement of the informant.
Yes, Lordship.
Here, all these four people whom we everything of getting back. Here, the petitioner before us.
Yes, Lord.
It's very to begin, to 74. After the police investigation, the registered as 58,
Yes.
28.
But petitioner number 4 is different, Lordship. Because it,
So you pay for.
no, Lordship, in the petition, Lordship,
What is the inquiry? Inquiry fix that for the informant is the.
We are request.
yes, sir.
Correct. So what is the point in keeping it pending here? You do whatever you want, they will take steps, whatever they think is proper.
Lordship.
But only fact is, my lord, they should immediately register FIR. Why is it in, my lord? 2 months fixed, my lord.
Okay,
Where people, why we come this?
You want you want the division bench to say that
No.
on the basis of this, please
No,
register
I am-
fire and then proceed with the investigation.
No, my lord.
You don't want that,
I know.
then,
I just,
no. Reserve arguments for deserving cases,
Well.
not here. Once we say that you are an accused person, then you will not even get bail in the trial court. You don't want that. But Mr. J. Ahmed, learned counsel for the petitioner, also heard Mr. S. K. Hazarika, learned government advocate for the respondents. Next para. This court, by order dated 8/12/2025, command requested the learned government advocate to obtain instructions as to whether the four petitioners herein are required in connection with any case lodged against them. Full stop. Next part. At the outset, the learned counsel for the petitioner has submitted that he has made a mistake in referring to the wrongfully RANGJULI, wrongfully outpost in the writ petition, which should have been wrong, sir, RONGSAI, police outpost. Next para. The learned government advocate has produced copy of written instructions dated 12/12/2025, along with along with 6-page enclosures wherein it is being projected that the that one Rajia Khatun, REJIA, Rajia Khatun, the complainant had lodged an FIR on 15/9/2025, alleging that during the night of 14/9/2025, unknown miscreants had stolen 4 number of cattle from her cow shed. Accordingly, GD entry, being the wrong side, G, SAI, GP, OP, GDE number 274 dated 15/9/2025 was registered. In course of inquiry, the investigating officer had visited the house of petitioner number 1 and 2 for the purpose of making an inquiry and without intending to arrest them. Stop. This 1 and 2 and 4 others. Stop. After the preliminary inquiry, the IO returned to the police outpost and made entry in general diary entry number 276 dated 15/9/2025. It is also projected that the complainant in her statement had accused all the 4 petitioners of being involved in the incident. Next para. As per the instructions, the IO never visited the house of the petitioner number P and 4, nor they were called to the police outpost. Next para. It has also been stated that the subsequent investigating officer on finding the offense to be cognizable, forwarded the complaint petition to the Lokhipool police station. Next. In view of above, as it is disclosed during police investigation that the 4 petitioners herein were the petition number 1 and 2 were subjected to police inquiry pursuant to the general diary entry referred above. And the fact that the FIR lodged on 15/9/2025 has been entered as GDE number 274 of 2025, dated 15/9/2025. Comma, the court is of the considered opinion that no fruitful purpose would be served in keeping the matter pending. So GDMD numbers also of alongside police station. Right? Accordingly, this matter stands closed. Liberty to the petitioners to take such steps as they may be so advised. All of the instructions produced are kept as a part of it.
Lookable case number.
It's not very so.
On the
They don't have, they have sent it to the police station. They don't know the case number. Cognizable offense was found. They have sent it to the main police station to have it registered. Well. Alongside.
Item 5 for motion.
Yes.
May I please, your lordship? My lord, the opinion, my lord may be pleased to find is at page 131, my lord.
131.
My lord, the original opinion. And my lord, later on a review petition has also been preferred. And that had also been dismissed, my lord. My lord, altogether, 21 numbers of exhibits had been relied on.
Where is the review petition?
My lord, the review application, my lord.
No, sorry, the order in review.
Order is at the last page, my lord. Starts at page 154, my lord.
But Mr. Here, we have a answer for the petitioner. And so for the respondents, comma, agreed by the opinion dated
54.
30/9/2024, page 131, passed by so.
I'm 25.
Thereby declaring the petitioner to be a foreigner of force inside the defense in the scheme. And order dated 30/8/2025, passed by the same learned tribunal in miscase number 2 of 2024. Being a review petition, page 154, which was also dismissed. The present date petition has been filed under Article 226 of the Constitution of India. Notice returnable in 4 weeks, extra copies within 2 days. For the record, following email address of the learned tribunal. Prayer for bail is opposed by the learned standing for the FP matters. Considering the projection, 10 days time to take bail of ₹5,000 to the satisfaction of Supreme Court Police Border.
Gwalpara, my lord.
Just talk of voice.
Mal. Highly obliged, my lord.
Item 6.
May I please, my lord? My lord, the impede order start from page 95, my lord. We challenge the order date 19/9/2025, my lord. Where the petitioner declared foreigner, my lord, post 1971, my lord.
This included commute method.
Yes, my lord. My lord, time period, my lord. Within how many days, my lord? My lord? My lord, lordship, obvious, my lord.
Item 7.
Ma'am, lordship, opinion lordship will find it page 69. 69 and 70. In this case, my lord, the petitioner has exhibited as many as 14 to 15 documents, my lord.
You have
From
to wait for some time for bail.
total list of lordship.
You have to wait for some time for bail till the records come.
Lordship, it is my lord, 10/7/24 order, my lord. She could not,
Whatever be the very good reason, we are not giving bail once they are delayed by more than a year.
lordship.
Right, Mr. S. Nath, Learned Counsel for the petitioner, and so also for the respondents. Opinion is at page 69, dated 10/7/2024, passed by so and so in case number so and so. DNGN inquiry number so and so, thereby declaring the petition to be a foreign of post 25 in sections. Notice returnable on, give a returnable date. 2025. Stock officer in the 2 days, call for the record to the following email address. The bail shall be considered on the receipt of the tribunal's records. Next, in the meantime, if the petitioner, namely so and so, alias so and so is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent Police Border,
Bongaigaon.
Bongaigaon, in the order to the notice of the said authority.
Lordship,
So and so.
Item 8.
Yes.
May I please, your lordship? My lord, page 93 is the opinion, my lord.
Page
93. 93.
Here we're giving bail. The essay Ahmed was offered the petitioner. So and so for the respondents. Page 93, opinion dated 26/6/2025. Passed by so and so in case number so and so, inquiry number so and so. Paying the petitioner to be a foreign of post 25 in 1971 stream. Noticed 4 weeks, extra copies, records to the following email address. Prayer for bail is opposed by the Learned Standing Counsel for the FT matters. Bail of rupees 5,000. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Shiv Sagar. List of 4 weeks.
Obliging.
Item 9.
May I please, your lordship? Lordship, order is at page number 77. Order is of dated 30/8/2025.
GA Sikar, Learned Counsel for the petitioner. page 77, order date 38/2025. Passed by so-and-so in FT case number so-and-so, reference case number so-and-so. Thereby declaring the petitioner to be a foreigner of 25/9/1. See, 4 weeks bail rupees 5,000 to the satisfaction of Superintendent of Police Border, Goalpara. List after 4 weeks.
Abhilash Lakshmi.
Item 10.
May it please your lordship. My lord, impugn order at page 75, contested case, my lord. It is of August 25.
Then we are pleased.
My lord.
You said, may it please your lordship. So if it's a recent opinion, then we are pleased.
Oblige your lordship.
M.A. Sheikh and counsel for the petitioner. Same order, bail. Opinion dated 28/2025. Passed by so-and-so in FT case number so-and-so. Police reference case, IMDT case number so-and-so. Declaring the petitioner to be a foreigner post 25/1971. Notice return will 4 weeks, extra copies. Reports to email address. Prayer for bail is proposed by the London Standing Council for the actual matters. 10 days time, take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border. Which place?
Goalpara, my lord.
Goalpara. List of books.
Oblige your lordship.
Item 11.
Hey, please, your lordships.
Yes, today,
My lord, petitioner is aggrieved by an ex parte order, my lord.
2018.
2018, my lord. Impugn order at page 47, annexer P14. My lord, what happened in this case, my lord, notice was served upon the petitioner, but before fixing the date of appearance on 7/4/2018. But in the meantime, my lord, petitioner was arrested in connection with an case, my lord. That's why he was sent to jail, my lord. And while he was in jail, in the meantime, my lord, ex parte order has been passed. My lord, kindly see
No,
the,
you can't be jailed for 7 years.
no, my lord. No,
Then-
please not. But my lord, I have explained the delay, my lord, in paragraph 19.
19.
Page 10, my lord. May I read, my lord? The petitioner begged to state that though he had received the notice of the FT case numbers on 17/3/2018, but as he was in jail due to the criminal case by the Rupuhibhat PS case number 187/18, he could not appear before the tribunal to prove his citizenship. In fact, the petitioner has no knowledge about the impugned ex parte order, as the same was passed while he was in jail. It is stated that he had been released from jail in the 3rd week of June 2018. Then his condition was serious and he was under treatment of Dr. So-and-so, Nagaon, with effect from 25/6/18 to 5/7/2018. The petitioner was,
But is any document there? We did not.
My lord,
Is any document?
he was a
For the
government
criminal case?
employee, my lord, he was also suspended
No, no.
after his arrest.
No, no, you. Page 43.
Medical suffering, my lord, for 20 to 25 days, my lord. I have not annexed, but I have the main ground, my lord. Then he after reinstatement in service, my lord, he met with the advocate, Miss Shima Kolita of Nagaon Court, and engaged her as his counsel and also paid her professional fees along with the relevant documents, including the notice which he had received earlier to do the needful, that is to prepare the written statement, etc. Then his engaged advocate assured him that he would do the needful, but even after several months, his advocate did not inform him about the ex parte order which was passed against him long back. Thereafter, the last part of 2019, the COVID pandemic ensued, which lasted till 2022. During that time, the petitioner did not receive any information from his advocate except that the proceeding of the case was halted due to pandemic. Thereafter, in the middle of the 2023, the petitioner again inquired about his case to his engaged counsel, who asked the petitioner not to worry and that she will communicate with the petitioner and as and when is necessary. After which the petitioner did not ask any about his case. Subsequently, in June 25, when the Assam police started a crackdown against suspected and declared illegal migrants, the petitioner came to know about the ex parte order dated 10/5/2018, passed in FT case number so and so. The police arrived at the petitioner's house searching for him on 16/6/25. And they informed the family members of the petitioners that an ex parte order was passed against the petitioner, wherein he was declared as a foreigner of post 25/3/71 string. The petitioner thereafter confronted his engaged counsel, Ms. Shima Kolita, who then told the petitioner that he will have to approach this Honorable High Court challenging the ex parte order. It is pertinent to mention herein that the petitioner was unaware of the procedure of filing complaint to the Bar Council. He could not do the same. Immediately thereafter, on 17/6/25, the petitioner applied for a certified copy of the said ex parte order and obtained the copy on 18/6/25. The petitioner thereafter took some time to come to Guwahati and find a counsel to file his writ petition, and finally on November 25, he met with his engaged counsel. The engaged counsel took some time to go through the documents and filed the instant writ petition at the earliest. Under the aforesaid circumstances, they humbly submitted that there is some delay on the part of the petitioner, which was not at all intentional, and as such, this honorable court may kindly condone the delay for the interest of justice. Petitioner states that his fundamental rights are involved in this case, and the claim made in the writ petition is legally sustainable, and as such, the aforementioned delay may be condoned to promote the substantial justice. My lord, petitioner is a fourth grade government employee, my lord. He has all the documents, my lord. I have an annex, my lord, from 1965 onwards, my lord. One chance may be given to the petitioner to produce those documents and to prove his case that he is not a foreigner, my lord. Otherwise, my lord, he may be, government may dismiss, he may be dismissed from service, my lord. Once after arrest, he was suspended, but after 1 year, he was reinstated. My lord, only delay ground, my lord, say, my lord, on annexes, my lord, I have annexed the documents, my lord, page 19 onwards, my lord. These are the documents enough to prove that he is a citizen of India.
Jasmine, yes. Get to there. Abdul Hakim. My lord, earlier this on.
But Mr. Dey, we are not finding any good case to issue notice also. You got the notice in 2018, you had a disability for 90 days. We understand that. We didn't give you leeway of more than a year. But from 19 to 22, you said that you engaged a lawyer who did not do anything.
My lord,
And after 22 till 25, again 2 years, nothing. This explanation, we don't find it a good reason to overlook that and issue notice the matter.
actually, my lord, he was not aware of the expert order, my lord. His engaged counsel, my lord, even not this.
No, we don't know. You see, there may be reason. You may engage a counsel
My lord,
and don't take steps. There are persons, few days back, we got a, what do you call, a matter where the doctor says that we have prescribed him the medicine, but he does not take it.
my lord,
So you can go to a doctor, but don't take his medicine.
in a similar matter, my lord, this honorable court delay about, my lord, in that case, my lord, in 2008, ex parte order was passed, but it was set aside in 2021, my lord. And it is held in that case, my lord. The citizenship being an important right of a person ordinarily should be decided on the basis of merit by considering the material evidences that may be adduced by the person concerned and not by way of default as happened in this present case. My lord, paragraph 4, my lord, 4 and 5. My lord, a chance may be given, my lord. He has the documents, my lord, only, my lord. Technical difficulties, my lord. That day also he is not aware of the ex parte order. That's why. Otherwise, the judgment 2013, 38. Judge to get the other expert of the expert order to get this one. 8. Yes.
Sorry, we are dismissing it. We can't permit such delayed challenge.
My lord, another judgment, my lord, of this honorable court, though it is old, my lord,
Yes.
in paragraph 6, my lord, and paragraph 9.
Okay, 2, 3, 4.
My lord, start paragraph two, I may be allowed to read paragraph two.
Yes.
2, 3, and 9 paragraph, my lord. Be it stated that the reference was made by the superintendent of police Dorong with the allegation that the petitioner was a foreigner who had illegally entered into Assam from Bangladesh after 25/3/71. The reference was registered FT case number so and so before the then Foreigners Tribunal Dorong, Mangoldoi. It is seen that the per report of the deposition border police constable entrusted with the duty serving notice upon the petitioner. Tribunal recorded that the notice was duly served upon the petitioner in presence of witnesses, but the petitioner did not appear before the tribunal and did not file a written statement. Consequently, tribunal decided to proceed ex parte and by the order dated 10/3/2008, answered the reference in favor of the state. Long after an application was filed by the petitioner for setting aside the aforesaid ex parte order, along with an application for condonation of delay, that was also rejected, my lord. Then, my lord, paragraph 9. However, having said that, we are also of the view that in such matters, it would be in the interest of justice to have an opinion on merit. For that reason, we intend to grant one more opportunity to the petitioner to contest the reference, notwithstanding her default and lesses. But at the same time, we are mindful of the fact that for whatever reasons, persons who are declared as foreigners continue to exercise their franchise in India as a citizen of India and with the NRC update exercise being presently undertaken, there is every likelihood of such persons getting their names entered into an NRC in the violation of the law. That is another. Therefore, paragraph 10, therefore, and having regard to the above, we issue the following directions. Order dated 10/3/2008 is set aside. Superintendent of Police Dorong shall produce the petitioner from detention. He was in detention. Detention before the Foreigners Tribunal Dorong at Mongoldo in connection with the FT case number so and so, 10 a.m. on which date petitioner shall file her written statement. My lord, one opportunity may be given. That is my humble submission before your lordships. Otherwise, my lord, he is a government employee, my lord, he need not to flood away or something like that. He is a government employee servicing since 2013, my lord. If he knows the fact, my lord, that ex parte order has been passed, he is supposed to appear before the tribunal, my lord. And moreover, he has engaged a lawyer but did not get any reply, my lord. That's why it is delayed. For the interest of justice, my lord. Any terms and conditions, my lord, any terms and conditions, my lord. Once chance may be given, my lord. Lordship, it is not the case that petitioner did not aware about the proceeding, lordship. He accepted the notice, lordship appeared before the tribunal, and after that, lordship, he got arrested, lordship, and no, he has not appeared. Before appearing, he was arrested. Did not appear. But he admitted that he accepted the notice, lordship. And lordship, after that, lordship, since 2019, lordship, COVID was completed in the year of February 2022. So after that, he was remained silent in about his case, lordship. And lordship, before police approaching his house, lordship, he never bothered about this case. Lordship. And lordship, lordship, in this regard, lordship, I want to rely on decision of this honorable court, lordship, WBC 2930/2025. WBC 2930/2025. Para 1213, lordship. WBC 2930/2025.
Name of the party?
MD, Majid Ali, ALI. MD Majid Ali. Yes, perfect.
In this case, he had appeared. In that case, he has appeared. In that case, petitioner appeared in that case. He said this. In my case, my lord, he was in jail. He could not appear. Triply opposite.
Supplementary item 27.
Impugn opinion petition in custody, my lord, in case 35. Custody 14 November 2025. Yes, my lord, the matter, my lord, the fact is that, my lord, the petitioner page 35, my lord. Petition. My lord, the notice was received, my lord, and only written statement submitted. Thereafter, my lord, the petitioner, lady and poor lady went to the Silchar, my lord, for daily wage labor. Thereafter, my lord, he was absent, my lord. Long time, my lord. When he was arrested, he come to know that, my lord. And no evidence, any document, my lord, was not. Yes, my 1411. The delay, my lord, I have explained, my lord, there are 8, my lord. May I read, my lord? Paragraph 8, page 9, my lord. The petitioner begged to the petitioner being a illiterate lady, my lord, complete depend on her English counsel. The English counsel advised her that he need not to come on every date. The learned counsel also advised he will be intimate the petitioner as and when his citizen is required. The learned counsel also gave them some impression, some paper. The petitioner stated after submitting his written statement, due to his financial hardship, the petitioner along with the husband went to the Silchar where the petitioner and her husband has been working in a labor in a big industry for their livelihood. The petitioner, while their petitioner was staying in Silchar, the petitioner was unable to contact our English council and due to the missing the contact number with his council. The English council also did not make any communication with the petitioner, and as such, the petitioner was not aware of the order by the tribunal. The petitioner stated on 14/11/2008 night, while the petitioner was housed, the petitioner was arrested by police personnel. After arresting the petitioner, came to know he was arrested in connection with so and so Christmas time. The petitioner begged to next matter, and since then the petitioner in detention came Matia, the district of Golkar. The petitioner begged to after getting the information, the petitioner was arrested. The petitioner's son-in-law went to the concerned tribunal on 1/12/2025, meet her English counsel and who was informed due to the missing the contact number. The English council could not inform about the order on the tribunal. The petitioner's son-in-law immediately applied certificate copy of order 4/7/2021 and which was provided on the same day, my lord. The petitioner stated that she is illiterate lady person having no sources and no necessity. On that ground, my lord, accordingly his son-in-law come to Guwahati on 2015 and meet Mr. Alishan, so the advocate of the government. On appraisal of the order, he asked to his son to come after 4 days to enable the vote for the record. Accordingly, petitioner's son again come on so date and requesting him to be necessary stay as possible as her mother-in-law in custody. Mr. Ali, with 2 days time, prepared the filing and the before this honorable court, accordingly, the instance case is filed today. Any illiterate person, my lord, no document was produced at that time, my lord. And he, due to financial, he went to their my lord with family member. Yes, sir. My lord, regarding this, my lord, we rely this is the order, my lord, regarding the those who contest by my lord expired otherwise, my lord. Any document was not submitted. My lord, I rely this to earlier. This is the two orders, my lord. The 2007 matter, 117 matter, 1 or 2007 matter. On the nature of the justice, my lord, both the cases they considered that part, my lord. One is expired in 2007, another is my lord 2017, my lord. Honorable Justice and Honorable Protestation, my lord, Honorable Visible Lord. My humble submission, my lord, the illiterate person, my lord, is not aware of this, my lord, and any evidence was not placed. Only the written statement was placed on. Hello, placement.
Upgraded item 21 for orders. WP Criminal 19/2025.
Yes. Your Lordship, I was detained police custody for overnight, Lordship, more than 12 hours, Lordship, without issuing any notice, Lordship. The subsequent stage, Lordship, GD entry has been registered, Lordship, that is on 10/4/2025, Lordship. And Lordship, the investigation has been closed, that is on only because of that, Lordship, finding that in the initial investigation that there is a commercial dispute, Lordship. But Lordship, if there is a commercial dispute, Lordship has been finding by the investigation officer or the police personnel, Lordship. But that is may not be required to pick up or brought me from my house, Lordship, or in degradation of my reputation, Lordship, in presence of my family member or presence of the public, Lordship. But there is a clear violation of the statutory provision under provision 35 of BNSS Act subclause 3, Lordship. Notice should be issued, Lordship. But only after registration of the GDNT, Lordship. After 2 days, Lordship, I was brought from my house, Lordship. Although in the affidavit, Lordship itself verified that, Lordship, the WhatsApp message has been sending to me, Lordship. But Lordship, not finding any response, if I did not respond to the said query, Lordship, to WhatsApp, Lordship. So it is may not be required to pick up or brought me from my house. That is my grievances, Lordship. So there is a special provision, Lordship, 35, Lordship, BNSS Act, may I please to read, Lordship, clause 3, Lordship. The police officer shall, in all cases where the arrest of a person is not required under subsection 1, issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicious exists that he has committed a cognizable offense to appear before him or at such other place as may be specified in the notice. No notice has been served upon me, Lordship. Well, in clear violation of the Honorable Supreme Court order, Lordship, that is the Satyendra Kumar until versus Central Bureau of Investigation 11th June 22, Lordship. There is a specific prescribed provision, Lordship, the increase of the initial investigation, if it is found there is no cognizable cases, Lordship, that the notice should be served to the accused. Citation, Lordship. Your Lordship. Your Lordship, 2022 10 SCC, Lordship, page number 51. Satyendra Kumar until versus CBR. Page number 51, Your Lordship.
5-1.
Your Lordship, kindly read this. Yeah. Last thing, para number 71, Lordship, clause B, as well as C and D, Lordship.
Well, the section 35 will not come here in my respective submission. Section 35 is under the heading of arrest of person. But in this case, there is no arrest. In fact, when an information comes to police, the police has the power to make an inquiry under section 173. No. Section 173 under BNSS logic provides that in case of information of information of cognizable cases, 173 but prior to that, kindly take up 172, 172 of BNSS. But it provides that persons bound to conform to lawful directions of police. All persons shall be bound to conform to the lawful directions of a police officer given in fulfillment of any of his duty under this chapter. A police officer may detain or remove any person resisting, refusing, ignoring, or discharging, or to conform to any directions given by him under subsection 1, and may either take such person before the magistrate or so and so. But ultimately, my submission is, the person is bound to conform to the lawful direction. And 173, kindly see subsection 3. Without prejudice to the provisions contained in section 175, on receipt of information relating to the commission of any cognizable offense, which is made punishable for 3 years or more, less than 7 years, but less than 7 years, the officer in charge of a police station may, with the prior permission from an officer not below the rank of DSP, considering the nature and gravity of the offense, proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days, or proceed with investigation when there exists a prima facie case. But in the affidavit, kindly come to the affidavit file on behalf of the respondent of 4 and 5. Page 38. It starts at page 37. Kindly come to page 38. But we have stated these facts, and information. No. FIR in fact. No.
FIR not here,
FIR is not.
FIR not here, FIR not here, not punished to us.
On 9/4/2025, one Rigusri Abraham, Assistant Manager of Offshore Infrastructure Limited, Lodge and Azahar, before the officer in charge Dispur Police Station alleging misappropriation of money by one Bikul Bora, proprietor of MS Soraighat Security and Service. Brief fact of the complaint lodged by the complainant is that Offshore Infrastructure Limited was allotted 2 contracts in Numaligarh Refinery and Saraighat Security Services has supplied 8 number of security guards in the said 2 contract sites. Further, Offshore Infrastructure Limited have an outstanding liability amounting to rupees 29 lakhs towards Seren Heavy Lift India Private Limited for hiring their crans on 24/3/2025 due to mistake on the part of the complainant side. An amount of rupees 29 lakhs 9,295 was wrongly credited to the account of Saraighat Security Services, and after detecting the mistake, they sent email to Saraighat Security and Services to refund the amount. It was further stated that initially Bipul Bora, proprietor of Saraighat Security, did not respond to their call and message. By email dated 29/3/2025, Bipul Bora admitted the receipt of the amount and sought few days time to refund the amount and intimated that he would return the amount by 2/4/2025. The complainant further stated that thereafter, Malak.
The complainant has an outstanding of rupees 29,900 towards Seren's Heavy Lift for their hiring their pay.
Yes, Malak.
That means the complainant is required to pay
To Seren.
Yes.
To
to
Seren.
Karen, to Seren's.
To Seren.
Now, payment was made to
Wrongly,
Saraighat Security,
wrongly to Saraighat,
Saraighat Security.
to the petitioner. To the
Yes.
petitioner here. And the complainant further stated that thereafter Bipul Bora had not responded the call and messages of the informant company, and ultimately they could be able to meet him personally on 8/4/2025 at Jurod, wherein he admitted that he withdraw an amount of rupees 20 lakhs from his account, and he would refund the amount of rupees 15 lakhs by 9/4/2025, and rest amount would be paid within 4-5 days. It was also stated that on 9/4/25, Sri Bipul Bora, instead of making payment of rupees 15 lakhs, sent an email to the effect that he will make part payment by 10/4/2025. On receipt of the Ezahar, the officer in charge of the Dispur police station gone through the contents of the same and finding that it disclosed a commercial offense, entrusted the deponent, the deponent of this affidavit, Kamal Sakuria, to carry out preliminary inquiry to ascertain whether there exists a prima facie case for investigation by GD entry number 54 dated 10/4/2025. During the course of preliminary inquiry, the deponent of the affidavit made several phone calls to Bipul Bora, but he did not respond. On 12/4/25 at about 4:16 PM, WhatsApp message was sent to Bipul Bora. He is not cooperating with the police,
4:16 AM. Even I will not cooperate.
4:16 PM.
PM. No, PM, okay.
Yes, your lord. PM not.
It is PM. 4:16 PM, WhatsApp message was also sent to Bipul Bora on his mobile phone number so-and-so, and he was asked to contact the inquiry officer. However, there was no response. Having no other alternative on 12/4/2025 at about 5:30 PM, the inquiry officer along with the police staff brought Bipul Bora from his home to the Dispur police station for the purpose of inquiry. After bringing Sri Bipul Bora to the police station, the informant was called over the phone and was asked to appear before the inquiry officer on 12/4/2025 itself. The informant informed that he is in Mumbai and therefore he would send their HR manager to the police station, who is coming from Numaligarh Golaghat by train to Guwahati. During examination, Bipul Bora admitted that he received the alleged amount, which he otherwise not entitled, and he would return the amount within a short span of time by selling his land, and he would settle the matter with the company. Situated thus, the Bipul Bora was asked to talk to HR manager of the company, who is coming from Numaligarh by train. He was allowed to sit in the police station and was asked to wait for the HR manager. In the meantime, he was medically examined, Chinchmarri police station. Inside the police station, Bipul Bora was allowed to roam freely. He was accompanied by his friend, namely Biren Gogoi. His son was also there, and his advocate, my learned friend, was also there in the police station with him. Copy of the complaint was shown to them. All of them are aware of the complaint. Then Sri Pradeep Kumar Sharma, HR manager of the company, arrived at Dispur police station in the morning on the next morning, on 13/4/25 at about 5:20 AM. During that period,
Yes.
During that period, when the manager, HR manager came, to reach the police station, during that period, the EO enquiry officer was outside the police station. Over phone, it was informed by Bipul Bora that the matter was resolved. At about 7:20 AM, both Pradeep Kumar Sharma and Bipul Bora approached the enquiry officer along with others, including their advocate, and apprised him that they have settled the matter and submitted compromise letter where Bipul Bora issued 2 bank checks dated 25/4/2025 and 8/5/2025 amounting to rupees so and so, the total amount to the company. And thereafter both left. The No, I took time, my lord. I took time. Lordship of the query that yes, my lord. That's Lordship.
Where's few of that?
My lord,
You are filing an affidavit, then you are saying that we have the records. If you call, we'll produce the records. Let's not be wait
my
to,
lord, CCTV footage, it is with us, my lord, and it was with us, and that I can produce, and the record kindly Lordship, some time may be given, my lord. I'll just produce it, my lord. Tomorrow in the morning I'll produce it.
if it's 2 or 3 days, we'll be more tied up. We can't be looking at the video of the police station.
Earlier,
He was,
pen drive was produced, but she was not,
no, pen drive was there.
effectively there. Pen drive to this.
Yes,
You bring it in a format which we can operate. Don't have it, what you call locked, transfer, what you call coded or transfer, coded so that we can't open that. Make it password free so that my secretary can show it to me.
and Lordship.
Or if there is a password, please give it to.
Yes,
my
yes,
secretary.
definitely. Take pen drive video. Live.
Because we are not stating in the order which record to produce, then because you say that we produced record A, you did not ask for record. B, we did not produce it.
Lordship, GD and complaint, whatever they have received, Lordship.
The FIR is not there. There's no reason not to produce the FIR.
Lordship.
No reduce not to produce the extract of the GD entries.
DDLT has
something
been
is
made out
happening
on the basis of the.
Something is happening in the police station at 5:33 AM.
No. In fact, at 5:20, the officer, the HR manager, he reached because he was from Golaghat, he was coming.
You have an experience of going to police station at 5 o'clock in the morning. You have it.
No, my lord.
I'll give you the name of a police station. Out of so many police stations in Guwahati, tell me one police station where you want us to visit at 5:33 AM. Tell us one police station, which is your ideal police station, most ideal police station, where we both can visit incognito at 5:33 AM. And I'll tell you the names of wonderful police stations where you can go and visit. 5:33. In my college days, I had the experience of going there. We are just adjourning it. We are not saying what to produce.
My lord.
We say that you want to. produce
Pen drive
records.
is with me, that
We
GD
say
and.
that you are
GD
wanting
and-
to proceed with the record.
Yes, my lord, GD and.
We are fixing it in the Wednesday of the first week. That will be
Lordship.
6th of January. 7th of January.
Seventh of January.
Yes.
7th of January.
What is that represented? Mr. So is that statement that you said you will produce the records as when directed?
Malad, page 41, Malad. Page 41.
Yes, leave of the court to produce.
Look,
So on a query of the court with regard to the subparagraph to paragraph 3I of the affidavit in opposition, comma, the learned senior government advocate raised for and is granted time to produce the records. Or the relevant records. It says that they list on 7/1/2026.
No.
Obliged.
Upgraded item 24. Upgraded item 24.
Hello, 24, 25 are connected matter. May I make a prayer, Lord? We kindly take up on Friday or Thursday, any day, my lord.
No, these are
Friday, this, my lord, this
no, these
Thursday,
are connected with review.
my lord, this Thursday or Friday, any day, my lord.
Okay.
Man.
Have this review, it's no problem. Review of 2013.
My lord.
Mr. Verma, be prepared.
Lordship.
Thursday,
My lord, Thursday.
which is a representative. Here made by Run Council for the applicant. This form.
Obliged, ma'am.
Item 12 for admission.
Mr. Mondo, the morning of prayer for made for adjournment, but we did not want to adjourn it since it's 2018 matter.
My lord.
Without looking at the records. Since this is a suo motu matter.
This suo motu, my lord, and what happened in this case, my lord?
There had made a mention.
Last, I think 2019, my lord, somebody mentioned that there is a review filed against the repeal order, the last
Yes.
order, my lord.
That's right, that's right.
My lord,
Yes.
who made that statement, my lord? One Mr. A.K. Talukdar.
Yes. No, that's why, in fact, since it's coming after a long time, I did not want to adjourn it without looking.
My
into
lord,
the
yes.
Mr. Then.
Review number 9.
One, my lord, Amina Khatun, she was, my lord, declared foreigner. Then, my lord, there's a repeat petition filed, repeat petition dismissed, then writ appeal filed. In writ appeal, my lord, that she has taken a plea that my sister has been declared
Indian.
as an Indian. So court dismissed the writ appeal dismissed, but there is a direction to register a suo motu case. Accordingly, this case is.
I understand.
So earlier occasion also this type of situation arise. I have got one judgment, probably he with him. One husband also with
In
him.
this case, lordship, the petty, respondent no one, lordship. She appeared before the tribunal, she adduced evidence, lordship, and she was declared by region order, she was declared a citizen of India, lordship. And lordship, her sister, lordship, she did not have any idea about the case of her sister. Her sister did not appear before the, it was an expert order against her sister, lordship.
No review, but who made that submission? Actually, I also forget.
To be an Indian, this suo motu case was registered.
My lord.
So that similar to this lines order can be passed.
Yes,
Perhaps that was the intention.
probably, my lord, and another order also similar to this. Okay? na?
I have not gone through the orders, lordship, but thing is that, lordship, I am appearing for the respondent one. He appeared before the tribunal, lordship. She adduced evidences, and by a regional order, she has been declared Indian citizen, lordship. Lordship, the trial court record has also come to our lordship.
Earlier occasion also, my lord, in the same family member to contradict your order was passed. Yes, it must have
It was verification on the part of the respondent one, lordship.
been.
No.
No, more record file करना है क्या नाम साइड पर ये तो सुन तो प्रूव
Oh, now we get it. What has happened?
my lord.
Para 7.
Yes, I now get it.
My lord.
The second opinion, the opinion which was passed at the later point of time declared the proceeding to be in India. Ignoring the previous opinion where the proceeding was declared to be a foreigner.
My lord.
So the order in this writ petition is to send both the matters.
Both the matters send back and take together. We had together and all the
Together,
document,
together.
because document for the same family is same, my lord.
Okay, but in
But
this case.
Here, this case, only two difference is that, my lord, earlier, which was, my lord, rejected by this honorable court, that was a ex parte. And it was inter parte.
Whatever be.
My lord, yes, my lord, the judicial parity has to be
Let's
followed,
see.
my lord.
Okay. That is why without understanding, I did not want to adjourn the matter.
No, I also surprised. I also tried to find out what is the review, but I did not find out, my lord.
No, it's
I did not get anything, my lord. That's why maybe, my lord, please escape my notice, my lord.
Mr.
Probably the two order I have placed before, one by him, my lord, from the
We
same
can
view, my
return
lord.
We are returning it to you.
My lord.
Is it you again to us? Yes. You should be more interested. Go through it. Take
Okay,
those, take the case numbers of both the cases. Because you'll have to assist us.
I'm out of 390.
But here in the 11.
No.
No.
Mr. P.J. Mountain, Senior Counsel, Assistant Senior Counsel and Senior Standing Counsel for the High Court. Assisted by Mr. A. Barwa, Learned Counsel. You are also appearing for R1,
R1, Lord.
but Mr. A.K. Talukdar was seeking time in the morning.
But who is he representing whom?
He was shown to be appearing for respondent 1, Lord.
One? You are appearing.
No, Talukdar also said he is appearing for respondent number 1. No,
So my learned friend, he is appearing for us number 1. You are for number
Yes,
8.
sir. Initially, he was Lordship.
No, he was in earlier
Lordship.
read appeal, which was.
No. In this case also, Lordship, perhaps
He was there.
he was
No,
initially.
I don't.
now you will be appearing.
Lordship.
Mr. N. Upadhyay, Counsel for Respondent number 1. Mr. G. Sharma, Learned Standing Counsel for the FT and FT border matters and NRC. And Mr. H.K. Hazarika, Learned Government Advocate are present. At the mentioned time, the Mr. A.K. Talukdar, Learned Counsel, had sought for adjournment. So however, the prayer for adjournment was deferred to be taken up when the matter is called. To stop. When the matter is called, Mr. N. Upadhyay, Learned Counsel, appears for respondent number 1 and submits that he is the counsel presently engaged for the respondent number 1. To stop. Next, madam. In as per order dated 6/8/2019, the submission made by Mr. A.K. Talukdar and counsel for the respondent number 1 has been recorded to the effect that review petition was filed on 6/8/2019, seeking review of the order dated 11/1/2018, passed in WA 3/8/2014. Post of has no documents to that effect is on record, the courtmaster was requested to check in the court website regarding review petition, if any pending in respect of order dated 11/1/2018, passed in WA 328 of 2014. To stop. Upon search, comma, no record of any review petition. It's said to be available. And accordingly, comma, the matter would be heard on merit as per the materials available on record. Next para. List the matter on. Mrs. Mohanta, tell us when we take it up?
After vacation?
You have a calendar, just take.
Yes, no, that is only about 26 there, yes. Definitely in 25 not be possible.
After we vacation.
27th of January,
No problem, my lord.
on 27. 1/2020.
26.
2026, yes. Biplab.
Obliged, Lord.
Item 13,
I think you are playing for adjournment. Yes. You are represented on the prayer made by learned counsel for the petition. The matter stands adjourned today. List of, give a date after. Yeah. 28. 28/1/2026. Yes, item 15.
item 15,
Presentation from the petitioner. All the respondents are represented by Angel Justice matters to be adjourned today. List on. Thank you. Yes, item 16. Yes, Mr. Vati.
May see your lordship. My lord, I have challenged the judgment on order dated 25/6/2025. Passed by the only single judge, my lord. And your lordship will find the order at page 117, my lord. In this particular case, my lord, I spoke an insurance policy, my lord. And subsequently, under that particular policy, I claimed for the loss or damage to my goods, my lord, and that was assessed. But my claim was rejected only on two grounds. First of all, that at the relevant time, I had no trade license, and second, that it was used as a godown, not as a shop. Though the policy has been taken in respect of soap, my lord. Now you will also will see the finding arrived at by the learned single judge at page 28, my lord.
Pardon me. Page 20. Please repeat again.
Page 28, my lord.
28.
Impugned order is at page 117. And the operative part, your lord will find. There are 28, 29, and 30.
Page 120.
Page 128, 129. May I read mine?
Yes.
Even if it is assumed that the contents of Mr. Bharti as the learned ombudsman has unduly placed reliance on the photos of the produced by the surveyor to suggest that the premises in question are used as a godown, in absence of any material from the claimant himself, that it was a soap and he has paid license for running such soap. This court in exercise of sorcery
judicial cannot interfere in award. Now, my lord, the reliance placed by almost upon the survey report in a summary procedure like the previous one, in absence of any cogent material being placed by the claimant, even person creating a doubt upon such survey report and or challenge to such survey report, your orders cannot be said to be perverse. Therefore, the argument advanced by Mr. Bhati in this context also is going to be negative. In the totality of the matter, the factual determination made by the improved award based on the material placed by the parties in the considered opinion, this court cannot be fastened between reasonable determination based on knowing that being the position court is not inclined to interfere with the improved award and passed by the way in excess of it to fix some matter. This is the finding, my lord. Now, my lord, first of all, I am taking to your lordship to the order passed by the ombudsman, my lord, at page 75. Yes, my lord. Yes. Go down, my lord. It is not the go down, my lord. It was the soap. And the policy was also taken of the soap, my lord. Even though, my lord, your lordship is well aware about the business places, the go down or the soap does not make any difference, my lord. And even though, my lord, that point, whether the burden to prove that it was a go down, that is on the insurance company, not upon me, my lord. Absolutely. Again, in insurance claims, my lord, the burden to prove that fact is upon the insurance. And whether that burden has been discharged, my lord, for that particular purpose, I am taking to your lordship to page 75. Ombudsman report, my award, my lord.
My lord, my brother has no serious objection, my lord. Later this appeal be admitted and heard on merits, my lord. And even though, my lord, your lordship will come to page 75, my lord. Page 75, the order passed by the ombudsman and the relevant portion is at page 75, my lord.
Got the shopkeeper's license renewed and presented it.
Yes, at that time it was not renewed. But your lordship is well aware about the provisions contained section 180 of the GMC Act, my lord. That does not bar absolutely that I cannot carry on the business without license. And once the license was granted to me to the interior date, my lord, in that case it is valid one. And it has to be assumed having been issued on the date when I apply for it.
You see, you are saying that you are using it as a shop. The burden is on you. If you can successfully show, then the ownership's on the insurance. The burden will not be on the insurance.
My lord, first of all, and secondly, my lord, your lordship has to see whether it is the material suppression of the fact, my lord. Had I intimated the insurance company at the time of obtaining the policy, my lord, that it is a go down, they would not have issued me the policy, my lord. That is not the contention at all, so far the insurance company is concerned. And apart from
Because
it,
you see, it's your declaration. They accept it at face value. You
yes,
took a shop insurance, shop owner's policy.
yes, that is there.
Shop owner's policy. is there.
And it was a soap, my lord. And for that one, my lord, if your lordship will come. Annexed ombudsman, how that finding is perverse or not, my lord. Because what the ombudsman has done, my lord, in this particular case, he admitted inadmissible evidence and left out the admissible evidence.
Yes, we have there at page 75. Page 75.
Page 75, relevant portion at page 77. This is done. Have you got it, my lord?
Yes.
We have taken into consideration the facts and circumstances of the case from the documentary as well as verbal submission made by the complainant and the representative insurance company. We have also gone through the records. It is evident from the survey report that at the time of close, the claimant was not having any trade license. They got a trade license. Trade license from Guwahati Municipality on 9/10/2020 after the incident. Trade license is a must for any type of business. So at the time of close, the business was not legalized by the competent authority. First ground, my lord. Second, though they have not GST certificate where the premises is mentioned. Moreover, from the photo and report of surveyor, it is clear that the premises was used as a godown and the policy was itself for a shopkeeper category and the proposal form, which has the contract value, it was mentioned the shopkeeper's insurance proposal form. Insurance has separate form for godown category as mentioned by the insurance representative during hearing. My lord, now he has relied upon the photos, my lord. Photos are post occurrence. Photos are post occurrence of the whether those photos can be relied, my lord, to justify that whether it was a soap or a godown. So it is inadmissible, my lord. And now your lordship is regarding trade license, my lord. May I take your lordship to the provisions of GMC Act, my lord, section 180. Because
carrying on the business without license is not barred and not illegal. One section 180 of the GMC Act, my lord, regarding obtaining the license, my lord, that does not bar that I cannot carry on the business without license. But I have to pay the penalty and other things. In this particular case, my lord, first of all, let us come to one section 180, my lord.
Don't read it, we don't have time. You just tell us, we take note of that.
Yes, my lord, because so far section 180 is concerned, my lord, that requires the license to be obtained. And I can carry on the business if I did not obtain it within the time, in the subsequently it can be granted. In the instant case, my lord, the application was made for license on 5/11/2019, my lord, at page 68. Page 68, my lord. Your lordship will see, on 5/11/2019, I made the application for license and the license was granted on 9/10/2020, page 70, my lord. Have you got it, my lord? Now, my lord, you will see year 2020-21. And up to 31st, valid up to 31st March 2021. In remark, your lordship will see 2029, 20 rupees penalty. They took the penalty from me, my lord, for regularization of the license, my lord. So that, my lord, it has to be presumed in law that I carried on the business with a valid trade license, my lord. 180 does not bar, my lord. There is no absolute bar that I cannot carry on the business without obtaining the license, my lord. Only thing that it can be seized. If at all, if I do not apply for it, I do not obtain it. In that case, they can seize it, close my business. That can be done, my lord. And in this particular, I paid the penalty. Since I paid the penalty, my license was regularized since 2019-20. So this aspect has not been considered, neither by the ombudsman nor by the learned single judge. First of all, there is no bar at all under section 80. Secondly, it has already been renewed for the previous years. So this is one aspect, my lord, regarding the trade license, my lord. I made the application and from the application, I'm entitled to carry on the business, my lord. It is not there that without applying, I carried on the business.
Where are the copy of photographs?
Photographs, my lord, I have not annexed.
You have the photographs, Mr.
Yes, sir, I have the photocopies of the photograph. I have annexed it with my affidavit, lordship.
Which page?
And page 87 onwards.
87.
87 onward, my lord, most probably.
86,
No, we wanted to
86,
look at the
87, 88. The photographs will go down. It's very clear. It comes out clearly.
It's a repetition only, repetition order.
Huh?
Repetition of this, no?
Affidavit in the rate petition.
Affidavit, that is not, I have not annexed, my lord.
Sir,
photos.
the court
And I
affidavit
read-
has not been annexed. That's the.
I'm ready to annex
Otherwise, I
the
would have
photos, my lord,
referred to
and to
certain-
produce the photos. But the question remains, my lord. Those photos,
Sit at the admission time. Let us see the photographs. If it is a part of the affidavit, it should have been here.
My affidavit would have clarified a lot of things. Doctor.
এই পত্রিকা নিকন আমি এই পত্রিকা নিকন অস্পষ্ট হয়ে যায় affidavit.
Yes.
Reopening day.
Reopening day, my lord, I may not be here. Let it be in the on 22 January. If it is not otherwise inconvenient for this honorable court. 21, 21st.
Readmission will continue.
My lord,
The entire affidavit may be, not only the photograph,
uh,
records in.
yes.
Record.
My
Records
lord,
also.
may I have the judgment, which your lordship has go down and warehouse in others.
Obliged.
My lord, sometimes these information may not be correct.
My father was in Venus. My father was in Venus. And if they remember. And they not have a dog. Let's be really clear, India. This what I was speaking of. Is. You know, the I engaged and that's how this. How that this machines and we have. I'll give it time.
Mostly it was in Paltan Bazar.
Yes. Opposite.
Business name.
It was for New India. It was for New India. New India had an office there.
Ah. Six, 16 or 17 years old.
Yes, ma'am. It can.